SJC-12643, Takia D. White v. Chief Justice of the Boston Municipal Court.
Good morning, Ms. White. When you get settled, you'll have 10 minutes. So you're up. You're up, so why don't you stand and go by the microphone. You were watching, you saw how others did it. So, and you have 10 minutes to address the court.
Sure. Good morning. Before we get started, I did have a handout that I wanted to be on the record regarding pro se law. So I will give the other side a copy of that.
Okay.
And now I can begin. Good morning, Your Honors. My name is Takia White, and I'm representing myself pro se. Thank you for your time. SJC Rule 313 calls for a complaint made on a clerk magistrate to be investigated. Is a clerk magistrate above an honorable justice or anyone else? That there is a systematic process made known to the public for an honorable justice to be held accountable, but there is none as it stands for a clerk magistrate at the Dorchester District Court and the Boston Municipal Court. I apologize in advance if I do not give this oral argument the complete justice that it deserves, and how I convey it to you.
Can I interrupt you, Ms. White? I hope you're going to tell us at least a little bit about what did the clerk magistrate do that you're unhappy with?
Yeah, I'm going to get into that.
Okay, that's fine.
Yep, I'm going to get right into that. Although, because of the simplicity and the fundamental facts of this case, I do not anticipate having any difficulty expressing the importance of my arguments to you here today. In addition, at any times during making this arguments, if I appear angry or frustrated, please excuse me. I will do my best to remain calm, as I have carried the weight of this case, as well as the people of the Commonwealth are carrying the weight of this case and this matter, although they may not be entirely aware. This being said, I've outlined several specific reasons that the previous judgment should be overturned. The first reasons being that the appellants, or my inherent rights to file a complaint of misconduct on a clerk magistrate and to have it properly investigated according to Rule SJC 313, were violated on several accounts. The first account being part of a root cause of this action, to address your point, Justice Link. The problem originated out of Dorchester Court, where the appellant, or I, was originally the defendant of a frivolous lawsuit. I filed for an appeal after having received an incorrect and egregious error made in the judgment made by Helen White, the clerk magistrate, where she failed to demonstrate her knowledge of basic mathematics by way of a very important email made from the plaintiff to the defendant at the time, which was me. An egregious error can also constitute misconduct. The email is profound evidence in that not only was it the direct evidence that got the magistrate Helen White decision overturned in my favor, it also clearly states by the opposing litigant's own writing that he was giving the defendant, me, a direct dollar amount discount. Further, it also explains his intent to specifically offer this discount from his previous email to me, although he originally submitted to the court that this was not his intent. Therefore, knowingly and willingly misrepresenting facts and perpetuating untruth to the court. This was later discovered, but for which he did not pay any damages. Following the original hearing, I asked the supervisor of Helen White at Dorchester District Court on or about March 26 how I could file a complaint against the magistrate for unfair treatment during the hearing, cutting me off several times and being impatient. As it appeared, she had been reassigned to hear cases that morning but was not previously scheduled. As a result, Helen White appeared angry when she entered the courtroom. It was first another magistrate hearing the cases by the name Valerie, I believe. It was explained to me by the supervisor on the day that I spoke to her, and while she was in unprofessional attire and dressed more suitable for a baseball game, appearing undignified for her work, she jerked her head back and forth, and she told me that I could not file a complaint on a clerk magistrate. and where the supervisor of the clerk magistrate did not properly assist me to file the complaint of misconduct. This is also a violation of professional duties for clerks and assistants of the court. I decided to write the Chief Justice of the BMC, being the headquarters of the DDC, or Dorchester District Court. I wrote 2 complaints, not just the complaint asking for her removal, but there was a complaint preceding that dated April the 19th that specifically talked about misconduct. In a letter dated July 12, 2018, Judge Roberto Ronquillo wrote to me and said that there has to be a number of complaints made on a clerk to consider her removal or otherwise. But I argue before you, the SJC rules call for the complaint to be investigated, not to be kept to themselves, and a public systematic process for filing a complaint of misconduct be kept a secret from the taxpaying public. Also, in another correspondence, same judge told me to go to the 2nd floor of the Brook Courthouse. There I went to the 2nd floor after receiving this letter, and where the supervisor there told me they did not have a process for accepting complaints on a magistrate for misconduct or otherwise. In addition, I attended a monthly community meeting by the Dorchester Coalition for Safe Neighborhoods, where I spoke with some representatives from the United States Department of Justice Community Division about the issue of not being able to access a public process to be able to file a complaint of misconduct or otherwise and have it investigated, at which time the representatives had informed me that they too had no knowledge of the process known to them or the public for the process of filing a complaint of misconduct or otherwise on a magistrate, but that they would investigate. Shortly thereafter, the United States Department of Justice contacted me regarding my verbal and written complaint to them, to inform me that there would be a community meeting held at Dorchester District Court, and which I did attend. This matter was concerning the issues that I had spoken with them about, also for the public to be able to voice any concerns. I have attached to my brief, I believe page 26 and 27, that document this community meeting, which I did attend, and there it was made clear to me and many other community members at the time that the Dorchester Court had been underserving the public with respect to this matter and others, and had brought the courts into disrepute, which is also a violation of SJC rules. I'm almost done. I openly, at this community meeting specifically about how, I asked specifically about how I could file a complaint, and even at this meeting, it had not been addressed or made known to the public of any, or how the public could go about getting their concerns documented and properly addressed. See pages 26 and 27 of my brief. Therefore, I submit to you that my constitutional rights to due process were violated on the grounds of my complaints not being properly acknowledged, investigated, and accepted into the record. In addition, the lower courts at Dorchester District Court and its magistrates continue to show bias and prejudice against me by showing the opposing litigant an increasing amount of favoritism by allowing him the rights after they had originally denied his request to continue my appeal hearing date to his convenience, and without mutual consent from me, which is what they originally told him he had to have. And without sufficient notice to me, who appeared on the original date set for by the court, at which time the opposing litigant did not appear and was not marked in default, but was rather received a courtesy call made by the magistrate of his whereabouts, at which time he was unavailable, and I was told repeatedly to go home. Federal law is clear in that pro se litigants in pursuing their legal plights are not to be taken advantage of, exploited for their ignorance of the law. Please see the handout that I'm giving you today, but should be properly assisted during the legal process, which I was not afforded these rights on several occasions as stated above. This is a direct violation of my constitutional rights and due process of law, which many people have fought and died for me to obtain. There must be a systematic process for the public to file complaints of misconduct on a clerk magistrate, and complaints must be investigated. Therefore, I respectfully ask this honorable court to immediately send this matter back to the lower courts to properly address these matters and comply with all SJC rules that apply. Thank you.
Okay, thank you.
Court, all rise.
Wait, I'm sorry, Mr. Quinn, you've not filed a brief. Is there anything you wish to argue?
I would offer a few comments if that's permitted.
All right, we'll give you a chance to offer a few comments.
Okay. So my first point would be that Ms. Takia White, contrary to her representations, does not have a legitimate cause of action against Assistant Clerk Magistrate Helen White. And that is because absolute judicial immunity extends to actors in the judicial system who are authorized to perform
What about filing a complaint? What about being able to just say, this person really treated me badly, discriminated against me, this is really not a
That type
professional
of-
thing. What do you do? What do you do if you're in that position?
Sure, that type of customer relations complaint is permitted.
And
The
where-
district
where-
court does have a public inquiry form, which it makes available to members of
Was
the
it made
public.
available to her?
I don't know that, because I'm here representing the Chief Justice of the Boston
I
Municipal.
understand that, but I'm just saying, I think that as a systemic matter, this may be an issue.
I think if there was an issue there, it was cured by Ms. White's filing of a letter with the Chief Justice of the Boston Municipal Court, which was investigated, and it was determined that it lacked substance, and therefore.
It was investigated.
It was investigated, yes.
Was she informed of this?
In the letter,
That it had been investigated and it was without merit?
well, it stated that the Chief Justice had reviewed the matter and determined that the allegations were without merit.
Okay.
Well, it says that you don't remove a clerk for a single action, right? The letter from Chief Justice Ronquillo's lawyer said that, right? That's the reasoning, and it applied our decision in the matter of Janet Rowe, right?
That's right. Actually, the process under the SJC rule does call for procedures that are set forth in the trial court personnel policies and procedures manual, which in turn calls for an investigation, which did occur here. And the manual states that based upon investigation, the appointing authority may conclude that no discipline is warranted, and that ends the matter, which is what happened here.
I was a little confused because there were two parts. There's an assistant clerk and a regular clerk discipline process.
Right.
The regular clerk seems like there's a standard process. The rule for the assistant clerks refers to a trial court policy. Is that policy, was there actual policy created for that?
Yes, there is, Your Honor.
And is that in the record anywhere? Because I couldn't find that in the record.
It is not in the record.
But there is a trial court policy on how you initiate a disciplinary process versus an assistant clerk.
That's right. And depending on whether the individual being investigated is unionized or not unionized, the procedure varies. If the employee is unionized, then there typically is progressive discipline if warranted, which could be appealed under the collective bargaining agreement. If the employee is managerial or non-unionized, then action might be proposed by the trial court's Human Resources Department. It must be reviewed by the court administrator. There is an appeal permitted to the Advisory Committee on Personnel Standards, but there is no further right of appeal to the courts specified in the manual.
But does the letter from Chief Justice Ronquillo, which is Exhibit A right on page 17 of this record, right?
Yes.
Does is that applying the process properly? Because it seems like it's a little more general.
Well, it perhaps could have been more specific in referencing the trial court manual. I will grant you that, yes.
So no one actually explained to Ms. White how you do this, right?
Well, she did write the letter, which set forth her complaint. That was investigated and was responded to. But beyond that, the particulars of the procedure, if there was a basis for discipline, was not explained to her because there was no basis for discipline here in the judgment of the Chief Justice.
Well, I understand the end result is different, but she has the right to file a complaint pursuant to this policy. She doesn't have a right to be part of a lawsuit, but she has a right to initiate the process, correct?
That's right, which she did.
And so she actually did it,
Yes.
and the process was triggered, but then they sort of jumped to the end result, which is that she's not in, there's no discipline required here, right?
Well, because if that is the outcome of the investigation, there is no further procedure.
Okay.
Okay, thank you.
Thank you.